Hello, and welcome to Immigration Talk, a space where we hear from an expert on matters related to the immigration industry, law and policy, and practice. I'm Rosalie Venstall-Dynan, and joining me is immigration lawyer Zeynab Ziaie Moayyed. Welcome, Zeynab.
Hi, Rosalie.
Zeynab, how might you advise clients regarding the processing delays and the operational backlogs that we're seeing?
Okay. Unfortunately, no one today is immune from the kind of long-term processing delays that we see, whether we're looking at temporary resident applications, permanent resident files, and even citizenship applications. And there will be some applicants who are in the middle of the process, but for anyone who's starting new, I think this is really important for us to educate them from the very beginning of the process in terms of the kinds of changes that can occur, including changes in processing times. We had a period of time where applicants were able to receive results very quickly, but we've definitely changed with the introduction of the much smaller numbers of applicants that are going to be processed in 2026, 27, and 28. And so doing that education piece at the beginning and having those honest conversations will help manage the expectations of applicants. I find that when we have those conversations up front, applicants can both plan their lives better, but also can understand the kinds of delays that we face from IRCC as well. In addition to that, I think the update in the IRCC tracker from last fall has been a mixed blessing in terms of giving applicants a more realistic view of how long their applications might potentially take. So starting in fall 2024, depending on when an application was submitted, there's a little bit more information in terms of how long the processing might take. It is disheartening and very difficult to have conversations with some applicants who are caught in much longer backlogs. So, for example, categories of applications such as humanitarian and compassionate applications that could be facing many years of application processing. But I think it gives us that opportunity to start the conversation and be able to show them the data and that they understand that they are not alone, that this is not just happening to their application, but is more of a system-wide issue as well. So as difficult as these conversations are, it's really important to have them. Internally, I think it's really important for us to have strategies to ensure that we don't lose track of any applications, that we do the necessary follow-ups, that we don't miss any communication that might be coming from IRCC, and that we are able to update IRCC if there are changes in our client circumstances. So building those internal systems. And related to that, again, particularly for new applications that are starting, making sure that our retainer agreements set out how we're going to deal with these longer processing times, right? A lot of immigration work is done on block fees. And typically, if they were done within, a year, there was only limited follow-ups that would be required, but now that processing might be several years, a lot more work might go into that. And so rethinking how you put those retainers together and how that additional work will be billed and that clients are ready for that as well. And finally, making sure that you're using every tool in the toolbox, right? As I said, there will be cases where it's a systemic issue. It is a policy change and a quota issue that IRCC is just not going to be processing applications faster. But on the other hand, we do see some applications that are significantly delayed when compared to other applications of the same category. And in those applications, they may benefit from pursuing a writ of mandamus in federal court. And this is certainly a case-by-case analysis, but when I say it's a tool in the toolbox, it's one that I think is worth exploring in some circumstances where applicants are in fact, in a situation, for example, citizenship application or an express entry application that has taken significantly longer than others in a similar situation. And I'll sort of end with this thought that while these systemic delays and policy decisions around quotas are fairly new, unfortunately, we have had at least one court case recently come out and say that the government might be justified in the way that it is, in fact, using these policies, and that the delays that come out of it are, in fact, legal delays, ones that are justified because of changes in policy. So, unfortunately, this means that we'll continue to have these difficult conversations with our clients, but the sooner we have them, the more they're aware of the circumstances. Hopefully they can plan better for their both immigration and visa matters, but also for their life as well.
Right. Definitely a challenge that everyone faces, clients and practitioners alike. Thank you for sharing some of your helpful strategies with us. Thank you.
You're welcome.
Let's talk again.